Good morning. I'm Christopher Davidson, State Archivist and Assistant Vice Chancellor over the University System with the University System of Georgia over the Georgia Archives. It is my pleasure to welcome you to the 2022 Georgia Archives History Symposium. The Georgia Archives is mandated to diffuse knowledge in regard to the state's history, encourage the study of Georgia history, and stimulate historical research. This symposium strives to do just that. As part of the University System of Georgia, we feel strongly about our efforts to provide education and outreach, and as such, see this symposium as one of our key events. Thank you to Hendry and his team for all their efforts. And finally, thank you to each of you for attending. I hope you enjoy and are stimulated to visit the Georgia Archives and research with us. We have a wide variety of accomplished presenters for this year's symposium. Up first is Mr. Andrew Bramlett, a student, volunteer at the Kennesaw Mountain National Park, and Vice President of the Kennesaw Historical Society. Mr. Bramlett is presenting on the Three Governors controversy. Following that is Mr. Larry Thomas's Building Your Case at the Courthouse. Mr. Thomas, who is a retired U.S. Army captain with more than 30 years of genealogy and research experience, provides an overview of researching courthouses for state records, land records, and other court papers and learning more about our ancestors. We will then have a brief break and return to the symposium schedule at 10:45 with constitutional law and same-sex marriage in Georgia, presented by Clayton State University professors Sheryne, Southard, Antoinette France-Harris, and Denise Allen. This panel examines Georgia's role in the 1986 U.S. Supreme Court case Bowers v. Hardwick and the eventual impact upon family law in Georgia. Sheryne Southard is Professor of Legal Studies and Online Program Coordinator at Clayton State University and worked as a trial attorney before joining the Clayton State University faculty. Antoinette France-Harris began practicing law in 1998, focusing on corporate, real estate, and estate law before embarking on a teaching and academic career at Atlanta Technical College and then Clayton State University. Denise Allen is a practicing attorney with experience in Florida and Georgia, focusing on family law, criminal law, and tort law, and began teaching courses at Clayton State University in 2014. Our final session is History of the Georgia Supreme Court, Augusta and Beyond, by Georgia Supreme Court Justice Carla Wong McMillan. Justice McMillan has served on the Georgia Supreme Court since April 2020. Born and raised in Augusta, Georgia, she is the first Asian Pacific American to serve on a state's highest court in the southern United States. After each presentation, we'll have time for a brief question and answer session and ask that you hold your questions until the end of each session, then type your questions into the chat box. Archive staff will read questions for the presenters. As a reminder, this and other programs will be available on the Georgia Archives YouTube channel. Without further ado, I'll hand the reins over to Andrew Bramlett.
Good morning, everyone. Georgia's Three Governors controversy is easily one of the most unique events to ever take place in our state's long history. In 1947, our state had not one, not two, but three men who claimed they were the...
Sorry, I got to get it on present mode. Sorry.
Oh.
Just a moment. I'm sorry, everybody. What would a presentation be without some technical glitches? So please just bear with me just a moment. All right, good to go. Thank you, Andrew. I'm sorry.
Taking place in 1947, our state had not one, not two, but three men who claimed to be the true governor of Georgia. All branches of our state government played a major role in this unprecedented event, but the importance of the judiciary in the controversy is often overlooked. The story begins with Democrat Eugene Talmage, the wild man from Sugar Creek. By the end of World War II, he had been elected governor of Georgia 3 times, 1932, 1934, and 1940. In the 1942 election, Ellis Einel ran for governor and won. Einel and Talmadge had been allies, but they had a falling out in 1940 after controversial firing of several UGA officials. Einel soon became a primary anti-Talmadge politician. In 1946, Talmadge decided to return to politics and run for a 4th term. Running against him would be former Governor U.F. Dixon Rivers, who went by Ed, well known for bringing the New Deal to Georgia, and James V. Jimmy Carmichael, who served mainly as Bell Bomber plant manager during World War II. Talmadge's main campaign issue in 1946 involved 2 U.S. Supreme Court rulings, Grovey versus Townsend and Smith versus Albright. For many years, the Democratic primaries in the South had been restricted to white voters only. The Republican Party in the South was practically non-existent, so it was not a factor in the integrated general election. This effectively made the entire election whites only. In 1935, the U.S. Supreme Court ruled in a case called Robbie versus Townsend that a white primary was constitutional. A Democratic Party was a private political organization and not a government institution. Several lawsuits filed in Texas by black voters eventually made their way to the U.S. Supreme Court. These lawsuits led to Roe's decision being reversed in the 1944 case, Smith versus Albright. Many Georgia officials ignored the decision since Smith versus Albright was about the Texas Democratic primary. As such, in 1944, Georgia Democratic primary was whites only. Columbus Minister Primus King tried to vote, was denied, and sued. King's case, called Chapman versus King, was successful, as the federal courts ruled the Georgia Democratic primary should be open to voters of all ages, all races. Talmadge found his campaign issue in this court case. During the 1946 election, he valued voters by trying to preserve the white primary, so I went forward one. The 1946 Georgia Democratic primary was the first to not be whites only. Jimmy Carmichael was expected to win the nomination, and he did receive the highest popular vote in the Democratic primary. However, due to the county unit system, which is Georgia's equivalent of the Electoral College, Talmadge emerged as the Democratic nominee. He easily won the general election. At the time of his election, Talmadge's health was failing rapidly. He was admitted to the hospital in late 1946 and was released soon afterwards. On returning to his home in McRae, Georgia, he was given a strict diet. According to an article by Ralph McGill in the December 4, 1946 edition of the Atlanta Constitution, he felt fine, and as he says himself, the Talmadge in him got the best of him. Surely little country fried ham and grits with red gravy wouldn't hurt even a baby, and everyone knows fried chicken and gravy with hot biscuits are as mild as milquetoast and a great deal more tasty. Partly because of these hearty meals, Governor-elect Eugene Talmage had been admitted to the hospital, and a wild man from Sugar Creek passed away December 21st, 1946. With the death of Talmadge, several claimed that they would serve as governor during the next term. The first claimant was Melvin Thompson, who in 1946 was elected the first lieutenant governor in state history. Since a lieutenant governor succeeds a governor, it only seemed natural that the lieutenant governor-elect would succeed the governor-elect. The legal basis for this claim was Article 5, Section 1, Paragraph 7 of the 1945 Georgia Constitution, which stated the lieutenant governor succeeds the governor. While Thompson's claim to the office makes a great deal of sense, he was not the new leader of the Talmadge faction. That honor belonged to Eugene Talmage's son, Herman. Section 1, Paragraph 4 was the basis of a Talmadge claim. This paragraph said that, in case of plurality instead of a majority, the legislature could choose the governor from the 2 highest vote getters. When the General Assembly met to decide the contest, they found 675 write-in votes for Herman Talmadge. Supporters of the Talmadge family had arranged these write-in votes for Herman because they knew Eugene was at death's door, and they were aware that paragraph 4 could keep a Talmadge governor. These 675 votes were enough for them to claim Herman had the second most votes in the general election, and thus should be the next governor. Many votes were later found to be fraudulent. When the General Assembly met in a joint session to elect a governor, 161 members of the General Assembly voted for Herman Talmadge to be governor. 87 members abstained. Shortly afterwards, Talmadge took the oath of office. Of course, two contenders have been discussed, and there's probably due governor's controversy. Alice Einel, whose term was about to expire, felt neither Talmadge nor Thompson had a claim to the office, and decided to continue serving as governor until the matter was resolved. Einel actually did have a legal basis for this claim, that in Article 5, Section 1, Paragraph 1 of the 1945 state constitution, which said that a governor could serve until his successor shall be chosen and qualified. Einel believed the legislature's selection of Talmadge was invalid, and therefore a successor had not been chosen and qualified. The next 3 months were chaos in the state government. Talmadge took over the reception's desk of the governor's office, while Einel retained the office itself. One night, Talmadge and supporters changed the locks to Einel's office, and was forced to relocate to the Capitol Rotunda. Einel was either tear-gassed or had a firecracker thrown at him, it's a disagreement on that matter, and was forced to relocate to his law office at the Candle Building in downtown Atlanta. He eventually announced his resignation in support of the Thompson claim. I should note there are many details of the story I don't have time to share today. The state seal was hidden, a great deal of alcohol was consumed, and each governor made their own conflicting political appointments. However, I hope this shortened version of the story gives a good impression of what happened. Legal challenges began almost as soon as the controversy started. After the Board of Pardons and Paroles refused to give Thompson budget information, a court case was filed in Rome. The judge ruled in Thompson's favor. Talmadge denounced the judge in the case, Claude Porter, and remained bitter about the ruling for many years. In Hendry County, Thompson sued to stop Talmadge from using executive authority. The judge in this case was Walter Hendricks, who ruled in Talmadge's favor. As a Dewey governor, Ellis Einel had ordered his staff be paid using funds held in the Fulton National Bank. The bank sued, as they did not want to pay the staff using state funds if Einel was not the actual governor. The judge in this court case was Bond Almond, lawyer appointed by Herman Talmadge to the Supreme Court of Georgia. He ruled in Talmadge's favor, but he acknowledged that a governor should represent the people, and less than 700 people had voted for Herman Talmadge. 3 other court cases involved the controversy, but none actually decided whether or not Thompson or Talmadge was governor. Because the court system could not agree on who the governor was, the case was sent to the Georgia Supreme Court. Oral arguments Thompson versus Talmadge took place on March 6, 1947. The Chief Justice in 1947 was William Franklin Jenkins. Jenkins was raised in Eatonton, where his father was Superior Court judge. Starting in 1916, Jenkins served on the Georgia Court of Appeals for 20 years. He joined the Supreme Court in 1936, when Eugene Talmage was governor. Jenkins, however, was an elected member of the court and was not appointed by Talmage. He did not have a solid connection to the Talmage family. He became Chief Justice in 1947. In addition to his legal efforts, he was well known for his support of William Shakespeare conspiracy theories. He believed that Christopher Marlowe wrote his plays and that Nicholas Breton wrote his sonnets. Associate Justice William Henry Duckworth was an elected member of the court as well. Duckworth was from Union County and was elected to the court in 1938. He was re-elected 6 years later. Associate Justice Reason Chestnut Bell was a native of Webster County, but he later moved to Thomasville. Governor Richard B. Russell appointed Bell to the court in 1932. Supporters of Russell and Talmadge had clashed in the 1936 Democratic state primary, when Russell and Talmadge competed to become the nominee. Russell was a Roosevelt supporter, and Talmadge counted the president among his enemies. In short, those appointed by Russell would have easily clashed with Talmadge supporters. Associate Justice William Yates Atkinson, Jr. of Noonan had been elected to the court in 1942. He had a strong interest in the case, as his father, William Gates Atkinson Sr., had served as governor of the 1890s. He was actually a very interesting governor. Each of the 3 remaining justices had been appointed by Ellis Einel. Lee Baron White was appointed in 1943 and elected to the court the following year. Thomas S. Cannon was appointed by Einel in August 1945 and elected to the court in November. He was a relative of Asa Candler, the businessman who turned Coca-Cola into a national brand. The final Associate Justice, Thomas Grady Head, was also appointed by Einel in 1945 and elected in November. None of the judges on the court in 1947 had strong connections to the Talmadge family, and several had been appointed by governors hostile to the dynasty. One of the arguments in Thompson versus Talmadge, by the Talmadge lawyers, was that the Supreme Court of Georgia lacked jurisdiction. Politics was run with the legislature, and the controversy was a purely political matter. Talmadge's lawyers also expressed the idea the legislature could choose the governor in various circumstances. According to one Talmadge lawyer, the election is not over when the people ballot. That is just part of the legislative process. Thompson's lawyers argue that the legislature's only role in gubernatorial elections was counting votes. The Supreme Court's opinion was announced on March 19, 1947. This critical event caused various responses. Some were outraged and others rejoiced. The way it was announced was actually rather unique. They got all the reporters from Atlanta and Georgia who came to hear the opinion and got them all in one room and locked the doors. They then handed out a copy of the court's opinion so that everyone could read it at the same time. And once everyone had finished reading, they unlocked the doors and everyone rushed out to get it to the papers and the radio. During this event, some even created commemorative envelopes celebrating the occasion, one of which I do have to share is in my personal collection. Of the 7 justices, 5 had agreed that Melvin Thompson was the legal acting governor of Georgia. Associate Justice Duckworth wrote the opinion. The majority of the opinion's basis went back to 1824, when the legislature's ability to choose a governor was revoked. The court ruled that Ellis Einel had been right in continuing to serve as governor past the end of his term, as successor had not been chosen and qualified. When Einel relinquished that claim, Thompson became the acting governor on January 18, 1947. Any actions taken by Talmadge were not valid. According to the ruling, the General Assembly can only pick a governor if no one receives a majority of the votes. The power would later be used in the 1966 election, and Georgia voted to remove that power in 1968. Because of the peculiar circumstances surrounding the 3 governors' controversy, the state Supreme Court ordered a special election be held the following year, in 1948. In the meantime, the 2 remaining judges each filed dissenting opinions. Associate Justice Candler asserted that Georgia Supreme Court does not have jurisdiction in the area, an argument made by Talmadge lawyers. Chief Justice Jenkins took a different approach. According to his dissenting opinion, claiming Thompson served as lieutenant governor succeeded Eugene Talmage, implied Eugene had served part of his 4th term as governor, an idea Jenkins rejected. Since a person has to be elected governor, and Webster's dictionary does not refer to a person as dead, Eugene Talmage could never have served as governor, according to Jenkins. Many expected the court's ruling would anger Herman Talmadge, and sure enough, it did. Since one of his father's campaign promises had been to defy the U.S. Supreme Court, there was also an expectation Herman Talmadge would try to fight for the court's ruling as well. Instead, Talmadge decided not to do anything reckless. This earned him the respect of many Georgians, and contributed to his election as governor of the 1948 special election. While many Talmadge supporters were unhappy with the ruling, many were glad to be rid of the Talmadge family, even if Herman came back soon. An editorial of the Atlanta Constitution on March 20th urged support for Thompson, as the court had spoken and given its opinion. The editor of the Constitution, Ralph McGill, stated that all good citizens will pledge and support in every measure which seems for the benefit of the state, in opposition to those which do not. No governor may or should expect more. In closing, McGill further stated the 3 governors' controversy that we must live by the law, to live in any other fashion would be anarchy. Now, I do have to share one story real quick. I did not include this in my presentation, it didn't occur to me. The Secretary of State at the time, and still is, the custodian of the state seal. Now, all official legislative acts by a governor have to have that seal. Secretary of State Ben Fortson realized that that was a very powerful thing. He didn't want it to fall into the hands of any governor. So he had to find a place to hide it. And sure enough, he hid it for 3 months and was not revealed where it was until the controversy had ended. Mr. Fortson was actually confined to a wheelchair, and turns out during that period, he'd been sitting on it the whole time. According to him, it left quite an impression. The reason I mention this right now is he was longest-serving Secretary of State in Georgia history, retiring in the 1970s. That's the namesake of the room I'm standing in right now. His portrait's looking at me. Are there any questions?
What was the relationship between Arnold, Thompson, and Talmadge after this controversy was over?
They evidently were rather not happy with each other. Arnold and Thompson got along pretty long. As I said, when Arnold went his claim, he supported Thompson. So they seemed to not have really many problems. Talmadge remained kind of bitter at both of them, but later kind of laughed about it at the end of his career. Evidently, remaining bitter about things is kind of a family trait of the Talmadges, so it's not really a surprise.
What was the most interesting thing, unusual thing that you found out in your research?
Definitely the thing I mentioned about Eugene Talmage eating the gravy and biscuits, and that's what did him in. There was a great book. Let me see if I know I have a note in here what it's called. Dewey Governor's Controversy, Skullduggery, Machinations, and the Decline of Georgia's Progressive Politics by Charles Bullock III, Scott E. Buchanan, and Robert Keith Gaddy. That provided a wonderful resource in putting this together. It was a great starting point, but it didn't mention the anecdote about Talmadge's biscuits and red-eyed gravy. And it was just such a great thing I had to share it.
I don't see any more questions.
Well, thank you everyone for attending, and now it's time for the next speaker.
All right, thank you so much for presenting, Andrew. My name is Hendry Miller. I've worked with all the presenters and the Symposium committee to get the symposium ready. Our next presenter is Mr. Larry Thomas. We've got about 5 minutes. Mr. Thomas, if you're ready, we can go ahead and start a few minutes early if you would like to, or otherwise we could take a quick break. It's up to you.
Yeah, we can go.
Okay. All right, I'm going to spotlight. Okay, Mr. Thomas is spotlighted. I want to take my spotlight off. And we'll turn it over to Mr. Thomas for his presentation, Build Your Case at the Courthouse. Mr. Thomas?
Well, good morning, and thank you for the invite. I do another quick brief introduction so people understand where I'm coming from. I tell people I'm northern born, but I'm southern bred. As you'll see, my Thomas line has been in Georgia since before the Revolutionary War, where we were patriots. And my mother's family is related to the Acres Mill family that ran the mill here in Cobb County. They just met and married in Chicago. So I grew up in the north, but drinking sweet tea and eating grits. And I've made Georgia my home. So we're going to get started here. We're going to talk about generic courthouses. Sometimes we're going to talk specifically Georgia. Other times just generic county courthouses. One thing you need to keep in mind, and we're going to start going. There we go. These presentations are being presented. They are copyrighted, so it is asked that people not make copies unless given express permission from the presenter. I always start with a disclaimer because a lot of people who are new to genealogy don't understand. History is what history was. Genealogists, like historians, we can't dismiss it, we can't whitewash it, we can't rewrite it, we don't even change the words. It is what it is. We treat it with proper respect as much as possible and context, but we're also going to take advantage to glean all the information from it, regardless of how ugly that part of our history is. So we don't want to be getting offended when we see words in these documents that are no longer considered politically correct in today's society. nor do we always want to apply 2022 morality to 100, 150 years ago, as we'll see later on in my presentation. So when I ask people, what do you expect to find in a courthouse when researching, my typical answers are wills, vital records, and they're looking for the land record for the homestead where the house was. But let me tell you, there's just so much more available at a courthouse if you would learn to look and learn what to look for. I mean, I've met people who have done research for, 10, 15, 20 years, and have never set foot in a courthouse, and they don't realize what all they're missing because everything is not digitized. Everything's not on microfilm. When the LDS Church first started coming into the courthouses, they would pick and choose what records they wanted to digitize, and they left a lot untouched. So if we don't actually get into the courthouses, we can miss those things that have not been microfilmed. So let's kind of break down basically how a county courthouse works. You have a clerk of the court. The primary responsibility of the clerk of the court is to maintain all the records of the courts, plural. They are overall in charge. Whether it's magistrate court, superior court, probate court, recorder's court, they are in charge of making sure those records are properly maintained. In the areas of a county courthouse, you know, we are looking for land and deeds, and typically they are in a different office all by themselves. We want to look at tax records. We're going to talk about some of these as we go along. Brands, if they had livestock, what were their brands? Were the brands similar between father and son or brother and brother? So there's lots of things we want to look for. And we want to ensure that when we're looking for the taxes, that we're looking both at the state and the county level, because the state often had copies to make sure they weren't being cheated by the county. What I'm giving you, I want you to take as a guideline, because every state, every county, every jurisdiction is different. For instance, in Georgia, we have a probate court. They don't have that in the Carolinas or Tennessee or Louisiana. It's called something entirely different. But they all have estate records. So we need to learn that when we're going into a courthouse, we're not asking for a specific court. We're asking for where do we find certain records. And every government entity in the United States must have some kind of record retention plan that says they're going to keep the records for so long in their house, you know, their building, wherever, and then they're going to do something with it, whether it is destroy it or transfer it to their own archives or send it to a state archive or national archives. There's a retention plan. So you might want to ask when dealing with historical records. For example, the Southern West Virginia District Federal Court will keep their records for 20 years. Then they transfer to the NARA, National Archives and Record Administration, in Philadelphia. So always ask where the records are maintained. Things we're looking for outside the norm in the courts is, did your ancestors serve as a juror? If they were on a jury, that tells you a couple things. One, they were male. In the old days, they were male. Two, they were at least 21 years of age. And three, there's usually a cap age of about 60 or 65, but not always. So you want to know what the law was. And if they're showing up, then they're in that line. This will also help you determine when junior first shows up. That means junior just turned about 21. Was your ancestor sued, or did they do, or were they suing somebody else? Now we think America right now is a litigious society. Honey, it's always been litigious, all the way back. I'm going to show you some examples. Did they give testimony in a civil dispute or in a criminal case? Was your ancestor charged with a federal or a criminal a crime of some sort, like a felony or a high-class misdemeanor? These are things you want to look for and you want to research and find out what happened. And sometimes you find the results of the lawsuits actually in the deed records because the judgment was against them. They didn't have the money to pay it, so they seized lands and had a sheriff's sale at auction. One of my clients, if you're familiar with this part of Cobb and Paulding County, he was sued by Mr. Austell himself, the same person that the city is named after. So we never know when we start looking. So at least in Georgia and many other states, you start with a magistrate's court that oversees the county operations, the county ordinance violations, civil disputes, and arrests and search warrants. In the Superior Court, they're dealing with higher level stuff like the real estate, deeds, plat, divorce, adoption, guardianship. Juvenile court usually falls under the purview, and felony and the higher class misdemeanor cases. Whereas probate court in Georgia and many southern states deals with vital records, estate records, and in the older days, it covered guardianship and conservatorship of a minor. And just because daddy died, mama didn't necessarily get absolute custody of the child if the courts did not see she had the financial wherewithal to take care of the child. So don't be surprised sometimes when the courts are stepping in back 100 plus years ago. And we're going to take a deeper look in a few of these in a few minutes, particularly with probate. But what about other states outside of Georgia? It may be called civil court. And the civil court is what's overseeing the county operations and disputes and handling real estate and deeds, divorce and adoption. And the criminal court is strictly just that, the crimes. There's recorder's court, and today we kind of think of that more as traffic court, business license issues, zoning, and other things that are just simply being recorded. But historically speaking, this is where the brands were recorded and the sale of property, not real estate property, but other property such as slaves and livestock. That was in recorder's court. So a lot of those records still survive if we go looking for them. And on a recent trip that I made to Ware County, which is where, of course, my family is from, in the time frame I needed, because of a courthouse fire, the only thing that survived was a book of livestock brands. Didn't help me much. But many major purchases are recorded in the recorder's court. Historically speaking, we would find inferior court, or you may see, sometimes you see JCIC, or JPIC, Justice of the Peace, inferior court. It was a lower level court, kind of like Court of Conscience, Chancery, and Equity, small claims court, minor misdemeanors. Now, Court of Conscience is, I've got asterisks by that. We actually have at least one surviving book from Burke County. It's at the Georgia State Archives, and I'm going to explain to you more. These are, sometimes you want to read these just for the fun of it, even if it's not your family member. But the Court of Chancery and Court of Equity were also courts that were typically used. Now, the Court of Conscience was established by Governor Reynolds in the colonial days. And in April of 1776, my ancestor Gilshot Thomas sued Isaac Cartwright. That when you see first name versus second name, the first name is the one doing the complaining, the plaintiff. The second one is the defendant having to defend themselves. And the case basically reads that the plaintiff, Gilshot, complained that the defendant, Isaac Cartwright, took a bell off one of his horses, and he produced a witness, Arthur Sharber, who, being duly sworn, made oath that he was in the company with Isaac Cartwright in the swamp. Gilshot had 250 acres of mostly swamp. He raised wild hogs, and heard him say that he was going to take the bell off the horse belonging to Gilshot Thomas. And then he heard the bell thrown into the river, which he assumed to be that bell. The horse returned back home without missing the bell. He also heard Cartwright say that when he was done with his crop of corn, he was going to take his gun, his tomahawk, and a wallet full of salt and go into the swamp and live on Gilshot Thomas's hogs and also Nathaniel Miller's hogs. Nathaniel Miller was a next door neighbor. The committee, taking the above into consideration, judged it expedient there, and therefore ordered that he pay 20 shillings to Gilshot Thomas for the offense and give surety, or a security, like a bond, for his good behavior. And the guy, Joseph Humphreys, became his bondsman. I find the story kind of funny, you know, but you learn about the families and the going on in these court records. They're there if we go back and we look historically at them. When we talk about tax records, everybody pays taxes. If you own, property, you're paying tax. Even if you didn't own property, but you're male, free male, between typically 21 and anywhere from 55 to 60 to 65, depending on the state law, you paid the poll tax. Now, a lot of people believe the poll tax was strictly a means to prevent free blacks from voting, and that's not true because the poll tax goes back to colonial days. It was called a tithe, Tythe, and it's been around. It had been around for hundreds of years. Yes, it was used in that after the war, but before that, it was typically males of militia age. So again, you may see some male paying property tax and not the poll tax because they were either under the age of 21 or they had become of age where they're no longer paying the tax. And this is still true of property taxes around the different places. Here in Cobb County, I filed my paperwork. I turned 62 last week, and next year I stopped paying the education school tax. That's public record. Anybody who pulls my property tax records will see in 2023, Larry Thomas did not pay education tax, which he did pay in 2022. So people know my age. It's public record. We can learn a lot just by looking at tax records. And they were not always kept inside the courthouse, so they're not always destroyed in a fire. You want to look. Post-Civil War in the South, a lot of times the poll tax now the freedmen had to pay, and a lot of times it was the employer that paid it. So you want to look for any kind of records. Business license taxes and business ledgers. I mentioned that my mother is related to the family that ran Acres Mill here in Georgia. Their ledger is at the state archives. It tells me how much money they brought in. It tells me who they employed every year, how much those employees were paid, whether they were freedmen or white men. All sorts of information is in that record at the state archives. If we just but look, okay? In many cases, again, the tax records are not stored at the courthouse, so don't assume. You want to look, especially, as I said, in Georgia, if you're researching Georgia, go back up to the state and see if there's a copy at the state. They have great listings at the state archives. It's also on Family Search. So you want to look. When we look at land and deeds, again, so many people just want to look at where they lived. Well, is that the only place they lived? Did they own other property? Did they transfer, buy and sell property, flipping property like people do today? A lot of people did. And you'll look at both the grantor, that's the person selling, and the grantee, the person obtaining the land. How did your ancestor obtain the land? When did they obtain the land? And was it through an estate because somebody died? How was it disposed of? Was it disposed of because they sold it? Did they give it to a family member? There's a lot of good information that you can research for genealogy in the land and deed records. And don't assume that it was destroyed because of a courthouse disaster. Here's why. If you owned a piece of property at the time that the courthouse was destroyed, you could not sell that property until you took a copy of your deed into the courthouse and refiled it. So here in Cobb County, I walked in one day and I said, I wanted to look at some records that were going to be before the Civil War. And they're like, we don't have any. I said, yeah, you do. No, we don't. Yes, you do. No, you don't. And look, just show me your oldest records. And then I looked through. I didn't find the one I was looking for, but I called every one of the clerks over and said, let me show you something so you better help people. And I looked at several examples. Here's the name, the person's name, and it says originally filed 1848, refiled in 1872. Another one, originally filed in 1859, refiled in 1868. They had to refile to prove they own the property. So don't be dismayed, again, just because of a courthouse disaster. And we know in Georgia there were lots of them. And some of these records will actually say who they obtained the land from and who that person obtained from. So you can track a lot of good information sometimes in the land records. One other thing you want to look for was whether your ancestor was an officer or a trustee in some kind of organization. And anytime you see the phrase et al, that's Latin for on others and others, it might mean it is an estate. It could be something like a church or civil organization like the Masons, the Elks, the Kiwanis. So these are things you want to look for. Sheriff sales are a little more tricky because sheriff sales were not always filed under the name of a property owner. All too often, they were filed under the name of the sheriff. So if you otherwise cannot see how the land was disposed of, find out the name of the sheriff and look under their name and see if you see where the property was seized or sold at auction for one reason or another. But again, we're thinking, okay, this is just land transfer. How is this going to relate to me doing family research? Well, I knew my great-grandparents here in Georgia had split. He and his third wife had split, whether it was legal separation or divorce or whatnot. And I couldn't find any record anywhere until I found this in the land records, the only legal document. And it says, on the 5th day of February, 1924, G.J. Thomas of said county and Dayton County of the first part, and Mrs. Unity Thomas of the said county and state aforesaid of the second part, witnesseth that the said party of the first part this day made the following agreement with the party of the second part. All this legalese is wonderful, isn't it? That whereas they have this day agreed to live in a state of separation, and in order to settle any and all claims that she may have against him and his estate for herself and her minor child. And at this point, there's only one daughter still surviving. The family story is that she had 2 daughters by GJ. She already had several children by her first husband. And she looked at him and said, I'm not a baby making factory, packed up and left. Eventually they moved to Raleigh. But the point being is, this is a legal separation, and the only legal document that exists is in the land and deed records. The last place most people would expect to find it. But if you're not looking, you can miss these things. The other area we tend to look for in probate is vital records. Birth certificates and birth registers. Birth certificates were not mandated nationwide until about 1919. Now, doesn't mean you won't find some back in colonial era, but they were not mandated until 1919. But oftentimes there's birth registers. Marriage license and applications. Now, I learned something new this week. I've been doing this for 30 years, and I learned something new this week. 1920 census for Bibb County in Macon lists a Lester Corker, his wife Adeline, and a 7-year-old daughter, Rosa Lee Corker. In 1930, she's listed as a 17-year-old Rosa Lee Corker. I'm trying to figure out what happened to her. Well, she marries in 1948. She actually remarries because she married a guy named Duncan, but I never could find that marriage record. She remarries in 1948, and on the application, it says she was never a Corker. Her father was Holly Merrick. Her mother was Adeline Daniels Merrick. Now I could find that her mother and Holly Merrick married before Adeline married Gordon Corker, and Holly Merrick dies. So Rosa Lee was never a Corker to begin with. That was in the application, because I could find no other record. So I've learned now to ask for marriage applications if they exist, because they would go in there and say who their parents were, whether their parents were alive or dead, and all sorts of good family information. We look at death certificates. We might want to look at death registers and mortuary records. The census schedule for mortuary records, 1850, 60, 70, and 80 can be a great piece of information. Here is where we might find an epidemic that hit. In 1860, there's a typhoid epidemic in Pierce County. My third great-grandfather died, one of his sons died, and a granddaughter died, all within a year of each other from typhoid. Each page of that 1860 U.S. Census mortuary schedule has spaces for 25 names. On average, 20 of those names are typhoid for that whole year in Ware County, or Pierce County, I'm sorry. So that's where you find, epidemics. Coroner's records, if there is a suspicious death, there may be coroner records that you might want to look for at the courthouse. In researching, at least in Georgia and many of the other states, probate court, you're going to walk in, you're going to be greeted by a clerk. Tell them what you're there to look for, what kind of estate records, and be nice, be polite, dress professionally, business casual, I say. It's in your handout. Because if you walk in looking like some slob off the street, they're not happy to see you and they're not happy to help. So just dress business casual and be very polite. And one of my distant cousins is actually the probate, one of the rural county courthouses. So I asked him to take these pictures for me. Made him nervous because he thought 40 people were going to show up on his doorstep the next day. I went, no. I just want to give an example. I won't even tell him what county. But inside a lot of these probate courts, you're going to find, they call it the vault. It is a fireproof room where these records are stored. We've had enough disasters from fires. So you're going to be led into there and you'll see all these big ledgers and books and drawers and whatnot. Now the ledgers are big and they are heavy and they are quite old. So this is a example of a birth registry for Appling County for the letter T, and I see my dad's two older sisters, Eula May and Thelma. One thing birth registries can tell you is for children who were born and died between the census, and there's no other record. But if you can look at the birth registries, grab them, look for them. And we see Eula May and Thelma. I know they're my grandparents, my dad's siblings, because the parents listed is Joseph H. Thomas and Viola Livingston. Well, underneath Thelma, I see Myrtle. I'm thinking, okay, that's GJ's other daughter. No, this Myrtle was born to a Leon Thomas and a Mamie Lee Holton. Wrong one. But the birth registries, the death registries will give you a lot of good information. Now, when we talk about birth certificates,
you go flip. There you go. Here are my father's two. That's right. Two validated birth certificates in Appling County. One has his name spelled O-D-Y-C-E, born 23 January of 1931. The other one is spelled O-D-I-S, born January 24th of 1931. And both say 11:30 p.m. How did this happen? I'm not too sure, but I have my suspicions. But which one is correct? That's the question you want to ask. Well, the birth registry only has one entry, ODIS and 24 January. And my father always spelt his name ODIS, and we always celebrated the 24th as his birthday. Ironically, he went to his grave believing his name to be Lester Otis Thomas, and that's what was on his driver's license, his army papers, his marriage license, everything about him said Lester Otis Thomas. But as you can see, there was never a Lester. Well, my father died a month before his father died. So we're cleaning up my grandfather's house down in Cochrane, and I came across these, and I looked at my aunt. I said, then where in the world did Lester come from? The oldest sister said, I hated the name as Otis. I called him Lester. So a nickname from his sister became his legal name. There was no legal methodology back in those days to actually change your name, so you may see it changed. And how all this happened? Not a one of my dad or his siblings were born in a hospital. My grandfather was very proud of the fact that he delivered all 7 of his children on the farm. He didn't need no doctor. He didn't need no midwife. He knew how to do it himself. And whenever he got around to going to town, he filed the paperwork. So that's probably how the mistake happened. But when we're talking about marriages, what if a marriage license was issued but never recorded, meaning it was never brought back in after the wedding took place? What does that indicate? It could indicate they were just lazy. It could indicate they never actually went through with the marriage. You have to look and see, were they living as husband and wife after the fact? Now, I've already talked about mortuary registers showing epidemics, and birth registers can allow us to see the patterns and other children that were born between the census. But again, there's so much information that we can get out of these records if we just look at them. Going back to probate court, my favorite one, we're going to kind of walk through some cases. So my great-grandfather, G.J. Thomas, like I said, his third wife packed up and moved out. She was done with the marriage. It was over with. So I wound up, using that and a few other things to help solve a mystery. So when we're looking at estate records, a lot of people just stop at the will. There's a danger in stopping at the will. A will does not require every legal heir to be named. Quite often, you will see that a will, particularly historically, will only list the names of the minor children. Why is that? Because the older children have already been taken care of one way or another. So you're missing their names. Intestate records is the best type. Intestate means they died without a will, or the will was, for one reason or another, thrown out in court and not accepted. Therefore, an administrator was appointed, and the administrator must identify every legal heir. Unfortunately, not all these records survived, but somewhere in the process of probating that estate, they had to show proof of every living heir. So we want to go through probate records. We want to look at guardianship records because they begin to tell a story about our ancestors. So my second great-grandfather was Banner Thomas. His wife was Mary Walker. He was born in Ware County, or Pierce County rather, Ware County when they got married, and he died in Appling County. He died in 1885. Now here are the lists of all the children that were alive at the time of his death. Now I want to point out a few things. James Mitchell, J.M. Thomas is the eldest. Vicey Ann, also known as LaVicey. Then my great-grandfather, G.J. Mary Thomas was not quite 21 when he died, so she was technically a minor for a couple months. Then Joseph Henry, Esther, Julia was 11. Nancy and John, the twins, were 9. And it took several years for this estate to close. When we start to look at estate records, the best place to go is the minute book. What the minute book does is it gives us line by line of every entry that was put in, every document that was filed. It doesn't tell us what's in it. It's just given a name and a location. It may be in that same minute book. It may be somewhere else, like inventory and appraisals, because somebody had some interested parties had to come in and do an inventory and appraise the property to ensure that there's fair equity. It may be in filing for year support. It may be in guardianship papers. You want to find every piece of paper that there is, every single one of them. And let me go back a moment. Typically, they may be found in these drawers that you can see in the back right-hand corner of this picture. Some places have actually pulled the loose papers out, and that's what they're called, loose papers, and put them in manila envelope or manila folders for you to pull and look at. Here's where you get all the nitty-gritty information, such as who is the administrator, all the possible heirs identified, and you want to read every bit of everything until the estate is closed. Now, I had a client that I'm doing research in South Carolina, and South Carolina and North Carolina both did a great job of digitizing those loose papers. So I'm looking at microfilm, and this one particular fella, born in the 1700s, died early 1800s. He didn't actually leave a will, and there were no 3x5 cards, but that's about what it reminded me of, was 3x5 cards, and he wrote on them, and he basically said, I don't want any of my kids to be mad at me, so here's who's getting what and why. And he proceeds to talk about every one of his children, when they were born, where they were born, who they married, if they moved out of Spartanburg, when they moved out of Spartanburg, where they moved to, who his parents were, who their parents were when they died, who his wife's parents were when they died. I mean, he's giving all sorts of information. I wish they all were that easy, you know? It would make our job a lot easier trying to find out about these families. But what you find in doing this research sometimes is that somebody already was given property, and you'll see in the land and deed transaction something to the effect of, for love and affection for my son, for love and affection for my daughter. And they give the property away. So the elder ones have been taken care of. Now, in another particular case, the man died in his will. He died in 1860. In his will, he lists one adult child as the executor, Junior, and then he only listed the minor children. But you wouldn't know this if all you looked at was the will. Well, what happened was the year was 1860, so 2 years later, Junior, 1862, dies in the Civil War. He's not married. He doesn't have any children. He didn't complete his task as administrator. And oh, by the way, he did go ahead and take his share of the land. So his siblings, it sounds mean, but it was actually a very smart legal maneuver. His siblings sued his estate. They forced everything back into court, everything back to one big pot, and let the judge of the courts redivide all the property. The advantages, we find the daughters, their husbands, some husbands died, the daughters remarried, the grandkids. We find all sorts of information because this case took over about 5 years to settle. We learn a lot by looking at this. Now, sometimes you find with the executor and the administrator they're changing for various reasons, and there could be juicy gossip there too. You know, we all like the juicy stories. So when we look at this particular one, this is coming from now Mary Walker Thomas when she dies in 1897. And almost all the children signed this petition to the court asking that their brother J.H. Thomas and E.F. Holland be appointed the private administrators. By this time, J.H. Thomas and E.F. Holland, a brother-in-law, have passed the bar exam. They're lawyers. Good people to be the administrator. But who's missing here is Julia. Story gets interesting. Because I actually had two mysteries that popped up with that. Now again, this is my great-grandfather, G.J. I just want to point out, his probate took 10 years to solve. And by then, my father was 5 years old. So when we're looking at these records, we want to look at the annual returns, because that's going to show us which heirs are still alive, who the minor children are, and we don't have their ages. As soon as they start disappearing from the annual return as a minor, you know they reach the ripe age of 21. Or in some states, females were 18. You see what money came in because they were owed, or what money went out and who got it. You all look at what items were sold, because a lot of times it was a family that buys it. Nowadays, you also have the additional paperwork of filing with the IRS an annual tax return. Been there, done that. But in this filing that we had for 1890, this is 5 years after Banner dies, Mary's still alive. She's doing the annual return, and she lists the minor children John, Nancy, and Easter, also known as Esther. Again, Julia is missing. Why? Well, we'll see that in a minute. But the other mystery pops up that all of a sudden now, my great-grandfather, G.J., is having to report as a guardian for his own son, J.M. Thomas. This just did not make sense. It was only J.M., not the other children. Why is this? That mystery got resolved several years later when I was talking to one of his grandchildren who remember him. And I asked, where is he buried? And she said, she told me this cemetery, Wesley Chapel there in Alma, Georgia. And I'm like, okay, I've never seen his grave marker. She said, find the two headstones for his first two wives. Look behind them, you'll see a blank slab. He was a mean man. He was a very mean man. His kids did not even think he deserved a real headstone. He's got a blank slab. Third wife left him. Kids didn't like him. And then I find out that his first wife, who died in childbirth, her father had given her property for her and her heirs. Well, when she died and he was doing his will, he didn't trust my great-grandfather to be the administrator or the guardian of his own grandson's property. He appointed GJ's father, Banner, to do it. Well, when Banner died, now it turned to GJ. But for that time until his son, JM's, turned 21 years old, GJ had to report to the court every year, and he could not sell the land. He could rent it with court permission. He could do all sorts of things with court permission, but he couldn't sell it. So it was a legal move. My great-grandfather was not a nice guy. You know, you learn these stories. But whatever happened to Julia, this was the interesting one. We see Julia is married. She's 14 years old, and she is married. But she's now being reported by a Mr. Bennett. How did this happen? Well, she went into court at the age of 14, a married woman, and fired her mother. That's exactly what this says. She showed to the court that she is 14 years of age and that she is not satisfied with her present guardian and desires her removal and wishes the court to appoint as guardian of her personal property Henry A. Bennett, who consented. That was her father-in-law. So again, I said, don't apply today's morality. 14-year-old girl, she's married, and she fired mama. So interesting family stories start to pop out. What was going on? Did mama not happy with the marriage? I don't know. I wasn't around. But we find all sorts of interesting information as we go through and look at what's in the courthouse. Again, with probate and estate records, we want to see who bought what. Are they related somehow? You want to look at the names. You may want to research some of those names. That's where we start finding son-in-laws, father-in-laws, brother-in-laws, sister-in-laws. We find the extended family. And in finding the extended family, we often find more information about our own ancestors that we're looking for. Were there any special considerations? I did one recently for a client that he had a daughter who had a, today modern terminology we would say mental disorder. She was special needs. And he said, if everything else has to be sold to take care of her, then that is what is to be done. She is to be taken care of. Now, I didn't know her specific condition until I found a later census. And again, going back to my early disclaimer, we cannot get offended at the terms that were used. But in one of the census records, she is listed as idiot. Modern days, mentally challenged. Whether she was kept at home or institutionalized, which she was later on, he made special considerations for her. You want to look for these because this will tell you more stories and more information about your family. What was sold? How much was it worth? This indicates how much money they had. Their lifestyle, what their occupation was. If you see a lot of blacksmith equipment being sold, chances are that's how they earn their living if you haven't found anything else. We're going to look at how it's dispersed. A child portion versus a grandchild. Sometimes this can help, especially with heirs of the same name. Case in point, when my grandfather died, his estate was divided 5 ways. His second wife, my great-grandmother, the only one I knew and loved, got 1/5. He had 4 living children. Each of them got 1/5. So Eula May got her 1/5. Thelma got her 1/5. But Uncle Millard had already died with leaving 3 children. So his 1/5 was divided into 3. My father, as I said, had already died. So his 1/5 was divided among his 4 children. So I received 1/4 of 1/5 of the estate. When you start seeing these fractions and these type of off numbers, and start thinking second and third generation, because it's being divided and divided and divided. It tells us who's still alive and where they're living if they know. Sometimes it says whereabouts unknown. Sometimes they tell the court we need to advertise in the Birmingham, Alabama to see if this person will pop up because we think they're somewhere in that area. You may see that also in the court records. If there's a civil suit going on, they're posting around where they think these people are living, saying come back here because you're being sued, and if you're not here, you'll lose by default. So we always want to look at estate records, at deeds, at civil cases, as to when they're advertising and where these people may be around. One thing to keep in mind when you go into some of these courthouses, some of them use very unique, and that's a very kind word I'm using, unique, indexing system. In your handout, I reference a book by Christine Rose. She talks in depth about these different indexes. Some of them are extremely challenging. I mean, you think you're just going to walk into the alphabetical? No, no, not even close. So you have to see how their indexing is being used and take a deep breath. If nothing else, ask one of the clerks to help you. Just again, be polite. Their job is to file the records. Their job really isn't to necessarily help you, but they will if you're nice and polite. Some will allow you to take in a scanner and a camera, and some won't. Cobb County does not want you taking pictures with your cell phone, so don't get caught. You may always want to ask first. Some places like Gwinnett County, everything is electronic now. Everything has been digitized. You're not going to get your hands on the original piece of paper. The exception might be is if you could show them that it was a bad digital copy, maybe, just maybe, they'll let you pull, or they'll pull the original and let you look at it. You just have to ask. Now, one thing you need to do, remember, is plan, plan, plan. Don't do as I did and show up at Dodge County morning one day. It's 10 o'clock in the morning, and the first thing I notice when I pull in is no American flag flying. First sign that there's a problem. I get out of my car, walk up, now you can't see, but there's a little sign on the door that says this building is closed by the health department indefinitely. My girlfriend loves to laugh at me. Don't do as Larry says, don't do as Larry does, do as Larry said. Call ahead, make sure they're going to be open. In this particular case, they had moved a lot of their records, but not all of them, over to the Chamber of Commerce. So I'm over in the Chamber of Commerce looking for the records that I needed. It was during my ProGen course, one of the professional genealogy courses. And I'm looking at the estate records, and I looked at one of the clerks. I said, by the way, I need to let you know that as I do my teaching, sometimes I talk about your daughter. But she gives me this look like, okay, what kind of weirdo are you? I'm like, you probably don't remember, I was here about Thanksgiving a year ago. School was out, and your daughter was here. And she wanted to help. She was, playful little girl and really cute. But she really wanted to help. I was trying to explain to her that these books are big, and they're very heavy, and they're very old. They were written 150 years ago. So her eyes got real big, her mouth drops open, she looks at me and she goes, did you write them? Yeah, no, girl, I'm not that old. Thank you very much for those kind thoughts. And the woman looked at me and said, well, she still doesn't have a governor in her mouth. And I replied, I'm 60 and I don't have a governor either, so we're in good company here. But these books are old. You have to be extremely careful with them. Some places may even require you to put on gloves. The papers are fragile, so be extremely, extremely careful for the next person doing research, please. Know what's available elsewhere. Know what's already digitized, so when you go into the courthouse, you're not spending time getting stuff that you could have gotten sitting at home, as a friend of mine, Diane Barfield, likes to put, in your bunny slippers at 2 o'clock in the morning. So you want to be able to go in the courthouse and get what you need. You don't want to spend a lot of time in the courthouse transcribing, but you do want to read everything that you're getting records of. Because what's going to upset you is when you get home and now you're reading through and it references, for more information, see Will Book C, page 57. And you didn't go get Will Book C, page 57. So read through to make sure that when you leave, you have gotten everything that you needed on that trip. There's more helpful hints in my handout. But one other thing that's extremely important that I didn't put on the slides, I'm not sure if I put in the handout. If you take a bunch of pictures, whether with a camera or with your phone, within a day or two, please rename your pictures from IMG 0001 to Will Book D, page 79, and tell it what it is. Because otherwise, 3 months later, you're going to be scratching your head going, okay, what is this picture of? Me, I make it a practice before I take a picture of page 57 of Will Book D to take a picture of the cover of Will Book D or Land Record 10 or whatever the book is. I take a picture of the cover. And then I take a picture of the actual page so that I can put it together and properly cite my cite my sources later on when I'm doing my write-up. All right. I hope I've given you kind of an idea that there's a lot of things you can learn at the courthouse. I do run a weekly blog. If you're interested, you can email me at this email address or hit me up at my website. And if I'm doing this right, let me see if I can unshare. Does that work?
You're spotlighted for everybody.
Are we here, Mr. Hendry?
Yep. Can you hear me? You are on. Your PowerPoint is no longer on the screen.
I'm not hearing you.
You are.
Maybe his. Ours is turned on.
Our microphone is turned on. John or Amanda, if you can put in the chat if you can hear me. Okay.
Do we have any questions?
Mr. Thomas, can you hear me?
Yes, ma'am.
Okay, yeah, all right, okay. We have a few questions. In regard to the poll tax, you mentioned that employers many times paid the freedman's poll tax. How would we know if the freedman paid or the employer paid?
By the ledger that it's recorded on. If it's on straight up on the property or the tax rolls, then the freedman paid it. If it's not listed there, but then listed under the corporate tax records, then the company paid it.
Okay, thank you. We have another question. How often did people have to refile property taxes in Georgia?
Every 2 years was the property tax records, but they're not all still in existence, unfortunately.
Okay. You said that your favorite records were estate records. What is your second favorite source?
The land records. Okay. But there's a challenge with land records because one of my branches I'm doing, there's 5 generations of renters. There are no land records. They're all in Chicago renting.
Well, I don't see any other questions right now.
And just so everybody knows, the voice you're hearing off to the side is our education director, Penny Cliff. I just wanted to introduce her a little bit while you're hearing those questions from her, and we'll hold another moment or two for if any other questions come in the chat. But in the meantime, happy belated birthday, Mr. Thomas. We're glad
Thank you.
50 years old.
Don't see any yet.
Yes, and Mr. Thomas did have a handout. I emailed it to the attendees yesterday afternoon. If anybody registered for the event after about 3 o'clock yesterday, just send me an email and I can email that to you. And if there's not any other questions, I will again say our thanks to Mr. Larry Thomas for presenting for us. Actually, we've got a question typing coming in, so we can bear with it just a moment.
No problem.
But we do appreciate you joining us on this Saturday morning.
I appreciate the offer.
Okay, it was just a comment, very informative, and thank you very much from one of the attendees.
Thank you. And thank you once again.
All right, so we will take a break until about 10:45, and then we'll return with our next presentation, Constitutional Law and Same-Sex Marriage in Georgia. So everybody grab a cup of coffee, stretch your legs, enjoy your break, and we'll see you back here in just a few more minutes. Good morning, everybody. I just want to say that we're a little bit of ahead schedule right now, but we will take our break all the way until 10:45. So please just bear with us, and we'll return in a little more than 15 minutes at 10:45 with our next session. Thank you. Good morning, everybody. We've just got about 5 more minutes of our break. Just in case anybody needs to finish getting their cup of coffee, stretching their legs, and join us back here at 10:45 for our next presentation, Constitutional Law and Same-Sex Marriage in Georgia. So just about 5 more minutes. Okay, it is 10:45 and we are now ready for our next presentation, Constitutional Law and Same-Sex Marriage in Georgia by Professors Sheryne Southard, Antoinette France-Harris, and Denise Allen, all from Clayton State University. And let me get their PowerPoint pulled up and ready to share. I want to spotlight Professor Southard, our first presenter for this panel, and get their PowerPoint up and loaded. And as I'm doing that, I just want to send another thanks to all of our presenters. Just a moment, let me get this shared. Okay. And I'm going to be taking cues from the professors as they go through, so I'll be advancing their slides for them. So if there's any slides that didn't work, please blame me and not them. And Professor Southard, if you want to take it away.
Thank you so much. My colleagues, Professor France-Harris, Professor Allen, and I are writing a Georgia family law textbook entitled Fundamentals of Georgia Family Law. And we have observed during the course of our research for this book that how the evolution of constitutional law related to same-sex relationships has redefined family law in Georgia. So I'm going to begin with the first phase of this evolutionary process, and that is the Bowers v. Hardwick case. Next slide, please. These are the facts of the case. It's 1982. The Atlanta police have arrived at the home of Michael Hardwick, featured here on the left, and they're planning to arrest him for failing to appear in court on charges of public drinking. Now, Michael's roommate allows the police to enter into the home, and while looking for Michael, they peer through a partially open door and observe him in the room with his male partner or companion engaging in oral sex. So Hardwick and his partner are both arrested on charges of violating the Georgia sodomy statute. Now, the DA's office chooses not to prosecute Hardwick under the charges of the sodomy. However, Hardwick chose to sue the state of Georgia on the basis that the Georgia statute, the sodomy statute, violated the U.S. Constitution. And that is why Georgia's Attorney General, Michael Bowers, appearing here on the right, is a defendant in this action. Next slide, please. Now, the Georgia statute in question reads as follows. First bullet point. A person commits the offense of sodomy when he performs or submits to any sexual act involving the sex organs of one person and the mouth or anus of another. Next bullet point. This offense is a felony and it carried a prison term of 1 to 20 years. Now, here's the procedural history of this case. We have Hardwick, who brings his action in federal district court. The federal district court dismissed the action for failure to state a claim. So Hardwick then appealed to the circuit court, the 11th Circuit, and the 11th Circuit Court found the contrary. They found that the statute violated the U.S. Constitution. It violated the fundamental right to privacy. But at the same time, another circuit court in the nation found the contrary. So we have a conflict in the circuits, which is a time that's ripe for the U.S. Supreme Court to give the country guidance, and that's exactly what they did. They chose to grant cert and to hear the case in 1986. Next bullet point. The Supreme Court had a divided decision. There was a 5-4 decision on this, so as split as it can possibly be. They found that the Georgia statute was constitutional, and their decision hinged in large part upon family law. They held that the right to privacy protects intimate aspects of marriage, procreation, contraception, family relationships, and child rearing from state interference. Next bullet point. But there was no connection between family, marriage, or procreation and homosexual activity. So this statute was upheld, and there were about similar statutes in about half of the states in the country. So about 25 states had similar statutes that criminalized sodomy, and all of those in one sweep were all upheld. Now, one footnote in this case, and that's footnote number 2, and that reads that a John and Mary Doe were also plaintiffs in this action. They alleged that they wished to engage in sexual activity prescribed in this statute, but they were deterred from doing so because of the statute as well as the arrest of Hardwick. So this ruling impacted not only homosexual couples, but heterosexuals as well. Next slide, please. We reached out to the Georgia Archives and asked the archivist if they could assist us in locating the Bowers v. Hardwick file. Now, because this was a federal case, the file was not at the state archives. However, they were able to locate the files of the governor at that time, Governor Joe Harris, and allowed us to review the correspondence that he received during the wake of this decision to see the nation's sentiment. So this first letter here is from an Ohio citizen who says, I am writing to convey my approval of the actions taken by the governor's office and the attorney general. He talks about AIDS and how this decision protects the health and economic stability of the country. Now, the next letter, next letter, is a handwritten letter from a citizen that says, I'm very proud of Georgia for upholding the Sodomy Law, and he or she cites Romans 6:13. So these are letters in support of the Supreme Court decision. The next slide, please. These next set of letters are certainly against the decision. The first is a handwritten letter or note from someone that apparently has an upcoming trip planned to Georgia. I'll read from the second paragraph, which is in cursive, so difficult to maybe see, but it reads that the thrust of this abridgment of privacy and civil rights will clearly encourage greater adventurism by those righteous perverts who wish to be in everyone's bedroom, including that of my wife and me, while we're there in November. And the final letter is one from a California resident that is expressing his concern. Again, reading from the second paragraph, it refers to a national disgrace and insult to have witnessed Georgia's contempt for human rights, personal liberties, and civil rights. So we can see from these letters that the collective sentiment of the nation is very consistent with the split decision of the Supreme Court in this decision. Now I'll turn it over to Professor France-Harris, who will discuss the next phase of this evolutionary process.
Thank you, Professor Southard. And it is and has been indeed an evolutionary process for us here in Georgia. It's interesting to note that the Supreme Court of Georgia eventually reversed itself and in 1998 struck down sodomy laws as unconstitutional. In a case entitled Powell versus Georgia that actually involved a heterosexual couple, the court held that the Georgia Constitution grants a stronger and broader right than the guarantees which are implied in the Fourth Amendment to the U.S. Constitution. So as a result, it held that outlawing such sexual activity, whether it was between consenting adults that were same-sex or opposite sex, is a violation of the state constitution. On a national level, what we saw eventually in 2003 is a case that we see outlined on this slide with the United States Supreme Court overruling its decision in Bowers in Lawrence versus Texas. Now, this case that is referenced here held that a Texas sodomy law violated the due process clause of the 14th Amendment of the United States Constitution. And what we were seeing in the United States is that despite the fact that we had changing societal attitudes towards same-sex relationships, at the time of the decision, 2003, 14 states, Puerto Rico, and the military still had laws against sodomy. And because this decision, Lawrence was a Supreme Court decision, now all states had to come in line and were bound to follow the holding and allow this sexual activity to go unpunished. But needless to say, and one of the frustrations in the law is even though law may change, attitudes and mores are slower to change. So just like we saw after Bowers, there was a split in thinking and split of opinion related to this area. And there were other methods that were used to continue to harass and arrest members of the LGBTQ community. So what the next slide shows is yet another evolution, and this one specific to same-sex marriage. So after the Lawrence decision, same-sex couples continued to use the court system to fight for equal rights under the law. And in 2015, nearly 30 years after Bowers, another pivotal case, Obergefell versus Hodges, changed the dynamics of family law once again in America. Now, Obergefell involved several same-sex couples in 4 states, Michigan, Kentucky, Ohio, and Tennessee, who filed lawsuits in federal district courts in their home states, claiming that state officials were violating their equal protection and due process rights by denying them the right to marry or to give full faith and credit to their out-of-state marriages. So what happened at the lowest level of the district courts is that the courts ruled in favor of the same-sex petitioners. Then the case went up to appeal in the U.S. Court of Appeals, and they reversed those lower court decisions and then found for the respective states. So eventually, as Professor Southard indicated, the cases made their way up to the Supreme Court and were consolidated in this Obergefell case. At the time of Obergefell, 2015, our law in Georgia was very similar to the laws in those states that I mentioned earlier. The official code of Georgia annotated section 19-3-3.1 and constitutional amendment 1 of the Georgia Constitution define marriage as, quote, a union of only a man and woman, unquote. Moreover, Georgia refused to recognize as legitimate any same-sex couples that married outside of Georgia and came to live in Georgia. So as a result, those same-sex couples could not enjoy the same benefits as opposite-sex couples. Then in 2015, as I said, with this Obergefell decision, things changed. Again, a very close decision like we saw in Bowers, a 5-4 decision, and the Supreme Court found that states were unconstitutionally not allowing same-sex couples to marry. So they basically invalidated those state laws to the extent that they excluded same-sex couples from civil marriages on the same terms and conditions as opposite-sex couples. The court's rationale was that under the due process and equal protection clauses of the U.S. Constitution, same-sex couples have a fundamental right to marry. And what we mean by fundamental rights are those that have the highest degree of protection in our court system from governmental encroachment. So what Obergefell did was firmly establish that same-sex couples can exercise the same fundamental right as opposite-sex couples to marry in all states, and that there is no lawful basis for one state to refuse to recognize a lawfully entered same-sex marriage performed in another state. So needless to say, these decisions that we've seen from Bowers and since Bowers have had a profound impact on redefining family and family law throughout the United States. And next, Professor Allen will address some of the impact that we have seen here in Georgia.
Thank you, Professor France-Harris. The changes in Georgia law and Georgia family law that redefine the concept of family. Family has historically referred to people who have a biological connection. Recent changes in the law have redefined our concept of family and the rights that people have to choose their names and their family. Family by choice and not biological relationship is evolving in the state of Georgia and the United States. There's a law in Georgia known as the Equitable Caregiver Law. It is cited at the official code of Georgia, annotated section 19.73.1. This law was enacted in July 2019. This statute creates a fundamental change in the area of family law. The statute provides a path for people who are not biologically related to a child to sue for custody and/or visitation rights. It had been well-established law that people with no biological connection to a child had no right to custody or visitation with that child. However, that changed in 2019 when the Georgia legislature provided a specific procedure that people with a strong connection to a child could follow to seek custody and visitation rights with a child with whom they have a caregiving relationship. This change in the law recognizes the importance and value of those who establish strong connections to a child and with whom they have no biological relationship. The law is relatively new, so there's not a lot of case law regarding the statute. However, there have been some appellate decisions that discuss the statute and the manner in which it should be applied. In order for a party to bring a lawsuit, that person must have standing or the right to bring the lawsuit. The Equitable Caregiver Statute provides that which must be done to have standing to sue under this law. The statute provides that in order to establish standing, the court shall first find by clear and convincing evidence that the individual has fully and completely undertaken a permanent, unequivocal, committed, and responsible parental role in the child's life. They must establish that the person engaged in consistent caretaking of the child, that they established a bonded and dependent relationship with the child, and that a parent of the child had supported that relationship at some point in time, and that the person had accepted full and permanent responsibilities as a parent of the child without expectation of financial remuneration. So this must be someone that seeks to be with the child because he or she has established a strong relationship with the child, has grown to love the child, is not looking for a financial remuneration. In Skinner v. Miles, this case was decided in 2017 by the Georgia Court of Appeals. The court indicated that which should be in the affidavit of one who seeks the status of equitable caregiver. And the court ruled that a person with no biological relationship with two minor children should be given equitable caregiver status as a result of that relationship that she developed with these children while she lived with their biological and adoptive mother. In that case, Robin Miles filed a lawsuit against Sarah Skinner under the Equitable Caregiver Statute. And she alleged that while she was in a relationship with Miss Skinner, they purchased a home together and discussed having children, that they sought to adopt children, but Miss Skinner actually adopted the child because at that time, a homosexual couple would not be given permission to adopt. But when she adopted the child, they gave the child Miss Miles' last name as her middle name to establish her relationship with the child. And after they adopted the child, Miss Skinner then became pregnant through artificial insemination. When she delivered the child was born to Miss Skinner. But when she named the child again, she gave her Miss Miles' last name as a middle name to again establish the relationship. The testimony was that both parties provided care for the children, both financially and physical care. The court, after hearing this, determined that it was in the best interest of the two minor children to grant Miss Miles a equitable caregiver status, which means she had the right to sue for custody or visitation with these children, similar to that right that you would have from the other parent if the parent was a male, if there was an actual divorce. Not only has the right to seek custody and visitation changed in Georgia, there's been a fundamental change in the way we look at name changes. Next slide, please. Name change for transgender people has been denied in the state of Georgia in the past. However, the Court of Appeals in 2017 cleared the path for people to file name changes to reflect their desired name. In regard to Feldhouse, cited at 340 Georgia 83, the Georgia Court of Appeals found that a person who seeks to change his or her name as a result of a transgender procedure, who follows the requirements of Georgia statutes when filing a petition for name change, should be granted that name change. In this particular case, the trial court denied a petition for a name change from an obviously female name to an obviously male name, stating that this was misleading and could be considered fraudulent. The Court of Appeals looked at that particular decision and determined that it was inappropriate, and that as long as a person complies with Georgia law, they may choose any name that they wish to have, and they require that the name be changed. Next slide, please. So they changed Rebecca Elizabeth Feldhouse to Rowan Elijah Feldhouse. That was the name of choice of that individual. The conclusion is that the landscape of family law and Georgia law has changed significantly. The cases and statutes that we have discussed touch on the issue of having the right to choose one's family and one's name based upon the life choices that people make and the relationships that they actually create. This redefinition of family law allows children to continue relationships that are important to them and permits people to choose whom they will engage with. The laws create rights and obligations that are equitable and preserve existing relationships, such as relationships that children create with step-parents, relationships that children create with significant people in their lives that are now being recognized in the state of Georgia. That fundamental change in family law changes the way we approach the word family and the way we define family. Thank you very much.
Okay, thank you all for presenting. I think I missed the last couple of cues there, and I apologize about that, but I very much thank you all for presenting. And then I believe we'll give it a second for any questions that come in.
Which states were the first to challenge the Sodomy Laws?
Were you all able to get that question?
You know, I don't have the answer to that question.
Okay.
That's something I'm sorry we didn't. We were really working specifically on Georgia law and Georgia law's presence in that arena, and so we don't know the question. I want to say that the Ninth Circuit, which is more West Coast, was the circuit that found contrary to what the 11th Circuit found. So I can give you a region, but not a specific state.
I think in doing our research, I had come across a map of all the different states and the year of enactment. If I can pull it up, I'll share the screen while we go on to the next question.
Okay.
What has been the Georgia public feeling about these new laws and these new statutes? Has it been positive? Has it been divisive? What have you seen?
Well, I think that there is a division, definitely, in terms of the way people look at the law. It is relatively new, so that's why we don't have as many appellate decisions in this arena as we might have had otherwise. But I think that it depends upon where you are in Georgia. It depends upon how conservative the state is, the area of the state is, and it depends upon the people that are present in any specific case. So I would say it would be divided, would be my opinion as a trial attorney.
Yeah, I think that that's definitely the case that you see with a lot of these decisions, that you have split opinions, just like our political views and religious views differ. So to do opinions on these matters. So, and Penny, to answer your question, I actually did find that chart. I can pull it up. Let me see if I can share my screen with you. Okay. So this is the map. Are you able to see the map?
We can.
Yes.
Yeah, so here it gives you some idea as to when these sodomy laws, actually sodomy was decriminalized. What you see in the darker colors here, it looks like Illinois was one of the first to decriminalize, then followed by, and that was in 1962. Then in 1971, we see some of the other states in this bluish color. So Colorado, Oregon, I think it's Delaware listed there, and some of the others. So it just gives you a sense, and I can share with you in the chat this chart in case you have an interest in seeing, for specific states and maybe to see it a little bit more clearly.
Have you finished your research for your book?
No, we're still in the process. And I was just thinking about all those letters that Professor Southard pulled up there. And I said, okay, we might need to get some reprint permissions to use some of this information, because I think it's, as a history major, I joked with Professors Allen and Southard that I geek out over this stuff that, when I came and visited the archives myself. So we definitely would like to include some of those historical facts in our text.
We definitely welcome all of you back to do some research, and we really appreciate you coming to the archives and researching our resources and presenting at this symposium. And I'm going to check the chat. We're about to switch presenters here, but I very much appreciate Professor Allen, Southard, and France-Harris for joining us this morning.
Thank you.
Thank you.
Okay. Thank you guys very much. If you wouldn't mind turning your cameras off, we're going to unspotlight you, and we're going to try and bring up Georgia Supreme Court Justice Carla Wong McMillan, who's joining us today after a conference. So she's got a very busy day, but we very much appreciate her joining us as well. And her presentation is called The History of the Georgia Supreme Court, Augusta and Beyond. If you give me just a moment, I'll get this her PowerPoint pulled up. And Justice McMillan, can you hear me?
Yes, I can hear you. Can you hear me?
Got it. Great. So let me get the PowerPoint pulled up and shared. And as I said before the last presentation, I will be advancing the slides. So if there's any issue, please blame me and not Justice McMillan. Can everybody see that? Okay. And Justice McMillan, you can take it away.
All right. Well, thank you so much for inviting me to speak at this symposium. It's my honor. I'm actually a history buff at heart and had once thought I would go to graduate school in history, but I went on to law school instead. But I still have very much a love of history, and am very excited about being able to present at the seminar today. Hendry asked me to speak because the Georgia Supreme Court just recently celebrated our 175th anniversary last year, and we held a 2-day seminar at the court to talk about the history and of the past 25, 50 years. We tend to celebrate every 25 years or so. So this is a presentation that I've adapted from that seminar. And I'm going to speak first, just give a brief history of the Supreme Court, and then I'm going to more specifically talk about justices from Augusta, where I grew up, and which is especially appropriate because we're starting to get into Masters Week coming up. So if you could take it to the next slide, please. So as I said, the Supreme Court just celebrated its 175th anniversary. And of course, you probably know that Georgia is actually much older than that. So Georgia was one of those states that at the beginning, we didn't have an appellate court system. So every court has a beginning, but our court, the Supreme Court of Georgia, was a long time in the making. And for many years, Georgia was the only state in the country without an appellate court. It wasn't until almost 58 years after Georgia became a state in 1788 that the legislature passed a law authorizing the formation of the Supreme Court. In the interim, a losing party's only recourse from an unfavorable decision in a superior court, that is the trial court, was to seek a new trial in the same court. In fact, the 1798 Constitution, the Georgia Constitution, expressly forbade any appellate process that would remove a case from the county in which the action originated. Now, there are a number of potential explanations for Georgia's lingering resistance to a statewide appellate court. Many Georgians at the time thought that such a court was needless and too costly, or that only the rich would be able to afford to pursue appeals to a centralized court. But looking back at the context, the history, the primary cause of Georgians' mistrust of the appellate courts appears to be a mistrust of the United States Supreme Court and bad feelings about some decisions of the U.S. Supreme Court, which beginning in 1793, issued a series of decisions seen as unfavorable to Georgia and its citizens. Two of the most notable of these opinions were Chisholm versus Georgia, announced in 1793, and Worcester versus Georgia, issued in 1832. And Chisholm, the U.S. Supreme Court allowed a citizen of South Carolina to bring a suit against the state of Georgia in federal court, and eventually entered a writ of damages against the state, a decision that prompted the ratification of the 11th Amendment to the U.S. Constitution, which prohibited federal courts from hearing such suits. And in the other case that I mentioned, Worcester, under Chief Justice John Marshall, the U.S. Supreme Court ruled that Georgia had no right to enforce its laws or regulations on Native American lands. So those two decisions, in addition to other actions by the federal government, made Georgians mistrustful of a centralized appellate court system. But nonetheless, in 1835, after decades of debate, the Supreme Court of Georgia was finally authorized by amendment to the 1798 Georgia Constitution. This amendment provided for a three-justice court with no original jurisdiction, whose members would be elected by the legislature and travel a circuit throughout the state. So this was 1835, but we still didn't have a court for the next 11 years because even though there was a constitutional amendment allowing for such a court, the General Assembly continued to debate the advisability of such a court. And it wasn't until 1845, December of 1845, that the Georgia legislature finally passed legislation creating the Supreme Court of Georgia. The Supreme Court, as I said, rode circuit, so there was no centralized location like there is today for the court. Instead, there were 9 circuits throughout the state, 9 cities where they held court, and the court held its first session in Talmadge, Georgia on January 26, 1846, during which a clerk and a court reporter were appointed and 13 attorneys were admitted to practice before the court. No oral argument was actually held at that session for the very practical reason was that there were no cases yet that had been presented for appellate review. So the court had 2 more rulemaking sessions after that in Macon in February 1846. And then finally, the court held its actual first oral argument on March 23rd, 1846 in Cassville. On the bench for those arguments were 3 justices, and back then there were only 3 justices, and they had been elected by the General Assembly. And you see a picture of them today. These are this is a painting or portrait that we have hanging in the Nathan Deal Judicial Center. And so we've got the first three justices, which are Joseph Henry Lumpkin of Lexington, Eugenius A. Nisbet of Macon, and Hiram Warner of Greenville. Now this was in 1846, and I joined the Supreme Court on April 10th, 2020, 174 years later. I was born and raised in Augusta, as I mentioned. I'm from Chinese heritage, and my father was also born and raised there. When I was first appointed to the Supreme Court, a question I got asked quite a bit was, when was the last time that the Supreme Court had a justice from Augusta? Augusta, after all, had been founded early in Georgia's history, had served as the state capital, and played a prominent role in the state. So after some research, it turns out that there have been 4 justices on the Georgia Supreme Court who have Augusta roots, 4 who served on the Supreme Court, and 1 of the 4 actually served on the United States Supreme Court. Next slide, please. So the most prominent justice to serve from Augusta was Joseph Rucker Lamar. When I was growing up in Augusta, there were several major landmarks named after Justice Lamar in town, including the Lamar Building in downtown Augusta, which at one point in time was the tallest office building in Augusta. And there was also an elementary school named after him, and his boyhood home stood in downtown Augusta. Although Justice Lamar was born in Elbert County, his family moved to Augusta when he was about 3 years old in 1860 because his father became the pastor of the Christian church in Augusta. The manse where they lived was located next to the manse for the Presbyterian church, which was occupied by the family of the Reverend Dr. Joseph Ruggles Wilson, whose son was the future President Woodrow Wilson. So Justice Lamar and future President Woodrow Wilson were neighbors growing up in downtown Augusta. Joseph Lamar graduated from the Academy of Richmond County and went to school there. Then he went on to the University of Georgia briefly, but then left for Bethany College in West Virginia. He later enrolled at Washington and Lee University in Virginia to study law, but then decided to return to Augusta to read law in the office of Henry Clay Foster. And back in those days, we actually didn't have a state bar of Georgia that barred lawyers. I'm actually at the State Bar of Georgia meeting today in Athens. That's what Hendry was referring to. And instead of having a bar exam, you would, back in those days, a lot of lawyers would read law. They would associate with another lawyer and study the law. And eventually, he was Justice Lamar was admitted to the Georgia bar in 1878, and then he started practicing in Augusta, became very prominent there, and to the extent that 10 years after he was barred as a lawyer, he ended up being elected to the legislature at the young age of 28. In 1898, Justice Lamar was appointed to the Georgia Supreme Court by the Georgia Supreme Court to the Board of Bar Examiners, where he served for about 10 years, with the last 5 as the chair of that committee. And that actually is a very prominent committee. It was a boon for Justice Lamar to be appointed to that. So you can see his star just rise and continuing to rise in Augusta, and his reputation having been built up throughout the state through his various appointments and his work in the legislature. In 1902, then Governor Joseph Terrell appointed Justice Lamar to the Georgia Supreme Court to fill an expired term, and he took office in January 1903. And it's interesting to note that Justice Lamar, he didn't have any judicial experience before being appointed to the highest court of this state. And I think that was fairly common back then, but he was a very experienced trial lawyer. Well, so he was appointed in January of 1903, and then Justice Lamar had to run for a statewide election in 1904. And he won that election. But then in 1905, he ended up resigning, and he wrote a letter about it. And he stated that he resigned due to, and I quote, overwork, ill health, homesickness, and financial considerations. Many of those issues still exist today for our court. We're a very, very busy court. And back then, the state had grown so much, but the court had only grown incrementally, and they were just a huge caseload, and they had to ride circuit. It was just a very tough job to be on the Georgia Supreme Court. So at that time, Justice Lamar, after he resigned from the Georgia Supreme Court, he and his wife returned to Augusta to his private law practice. And there, in just a few years later, in 1908, he met President William Howard Taft in Augusta. And it's an interesting story, but back in those times, Augusta was a resort city. A lot of people would come to Augusta for a vacation, and President Taft actually came after his election, and he spent some time in Augusta organizing his cabinet, and he spent several months there. And so it was during that time that then President-elect Taft met Joseph Lamar. And then when the opportunity arose a couple years later, when there was a vacancy on the U.S. Supreme Court, brought on by the retirement of William H. Moody, President Taft remembered back to the time when he played golf in Augusta, and he ended up appointing Joseph Lamar to the U.S. Supreme Court. Unlike the contentious confirmation hearings that happen these days, Justice Lamar was confirmed unanimously by the Senate, and he took his seat on January 3rd, 1911. And I think he would have considered serving for a long time, but unfortunately, he had some health problems. In September of 1915, he suffered a stroke that prevented him from taking his seat on in the new term of court. And he passed away the following January 1916. Justice Lamar has the distinction of being the only person in Georgia to have served both on our state Supreme Court and the U.S. Supreme Court. And for those of you who are interested in court history, the Georgia Supreme Court cases are published in volumes called the Georgia Reports. And in addition to cases, from time to time, we will publish memoriams for our colleagues who may have passed away or retired. And there's a memoriam for Justice Lamar. It can be found at the citation 146, Georgia Reports 841. And I encourage you to take a look at that if you're interested more in his history. But in the course of researching for the 175th anniversary, we discovered two other Georgia Supreme Court justices from Augusta, two justices that, frankly, everyone had long forgotten about, Ebenezer Starnes and William Watts Montgomery. If you could go to the next slide, please. All right, so this is the only picture I could find of Justice Ebenezer Starnes. Justice Starnes was born in or around Augusta in 1810, and little is known about his early life, but in his memoriam in the Georgia Reports, he's described, and I quote, beginning life with no peculiar advantages of fortune or family connections, and not gifted with those brilliant qualities that strike and dazzle the public eye. His rise in life was steady, regular, and due to patient industry, perseverance, and unswerving integrity. So he just sounds like a very steady person, worked really hard to get where he ended up going. So Justice Starnes went to college and then ended up getting a master's degree from the University of Georgia in 1832, and he was admitted to the bar shortly thereafter that. Justice Starnes, then Attorney Starnes, became the Attorney General of Georgia in 1834, which I find a little bit interesting because he was just admitted to the bar in like 1832, and then 2 years later he becomes the Attorney General of the state of Georgia. And he ended up serving in that capacity until 1840. And then he went back to private practice, and on November 13th, 1849, about 9 years later, Starnes becomes the judge of the Superior Court of the Middle Circuit, where he ably served as a trial court judge until he was appointed by Governor Howell Cobb to the Georgia Supreme Court on November 15th, 1853, to fill the unexpired term of Justice Hiram B. Warner, who, as if you recall, he was one of the first 3 justices of the Georgia Supreme Court. And so Justice Starnes was appointed in that court just right after that. And in the course of doing my research, I don't have a copy of this in this slide presentation, but the executive order appointing Justice Starnes is located in the Georgia Archives online collection. You can search it and look at that. Justice Eugene Nisbet, also one of the first justices of the Georgia Supreme Court, has a description of Justice Starnes in his unpublished diary as follows. And I found this quote to be kind of interesting. Justice Nisbet described Justice Starnes as, quote, "His voice is bad, and he hems and haws and drawls outrageously, but his judgment showed clear discrimination and strength." And those of you who know people from Augusta, and I don't think I have an Augusta drawl, but there certainly is an Augusta drawl, and it sounds like Justice Starnes had that. So Justice Starnes served for a little over a year on the Supreme Court until 1855. So he only served from 1853 to 1855. He actually failed to get reelected. So here in the state, even if you get appointed as a Supreme Court justice, you do have to win election in order to keep your seat. And unfortunately, Justice Starnes lost his election after only 2 years on the court. And he went back to Augusta and back to private practice, but he held no other office in the last 13 years of his life. You can see from the headstone, which is located in the Somerville Cemetery in Augusta, Georgia, that he died on March 20th, 1868. And there's a memorial for Justice Starnes in 37 Georgia Reports 511, and that memoriam recounts that the justice's death was very sudden and unexpected. Next slide, please. So the other lesser known Augusta justice that we were able to find in the research is Justice William Watts Montgomery. And a lot of times you see him he called himself W.W. Montgomery. Justice Montgomery was born in Augusta in 1827. He attended Georgetown College and then the University of Georgia, and he was admitted to the Georgia bar on June 13th, 1849. He then entered private practice in Waynesboro with John Shoemake, but because of his health, he ended up, Justice Montgomery moved back to Augusta in 1854. And just like Justice Starnes, Justice Montgomery also ended up serving as the Solicitor General for the Middle Circuit, of which Richmond County, Augusta, was a part. And at that time, the Solicitor General for the Middle Circuit was also recognized as the Attorney General of Georgia. And he served in that capacity during the Civil War from 1861 to 1865. And then after the war, he returned to private practice with ex-Governor Herschel Johnson. So just a few years after the Civil War in 1872, Justice Montgomery was appointed by Governor James Melton Smith to fill a vacancy on the Supreme Court. And his term expired the following year, and I couldn't really find much about why he decided not to run for election, but he just does not appear that Justice Montgomery ran for election. I guess he was fine with serving just a year or so on the court. After his term expired, he returned to Augusta and entered into a partnership with yet another judge, Judge James Hook. During Justice Montgomery's very brief time on the court, he was known for a decision upholding the constitutionality of the laws of the session of 1870, a case in which Chief Justice Warner dissented. And just a bit of trivia and interesting fact about Justice Montgomery when I was researching him was that he was known as a chess champion. And one of the pioneer chess editors in the United States. I think he edited a magazine about chess. Next slide, please. And Justice Montgomery died on January 9th, 1897, and he's buried in the Somerville Cemetery in Augusta with Justice Starnes, and a memoriam can be found for him in 100 Georgia Reports 795. Next slide, please. So I've talked about 3 justices on the Georgia Supreme Court, and they're fairly long time ago. Justice Lamar served in the early 1900s. Well, I was sworn into the Georgia Supreme Court on April 10th, 2020, almost 115 years after Justice Lamar served on the court. And I am the next Augusta justice. And so you'll see from this picture, here's my investiture with Governor Kemp. This was a socially distanced swearing in. This was right at the beginning of the pandemic. And normally, in normal times when there's an investiture these days, it happens in the House chamber in the Capitol. But given the circumstances, no one except my immediate family were allowed to go to the investiture. Members of the court were not allowed to go to witness it. And I wasn't allowed to tell anyone that it was happening because the governor's office did not want anyone just dropping by. So it was kind of a secret affair. And so here I am getting sworn in. This is Liberty Plaza, by the way, right outside, right behind the Georgia Capitol. I'm sure Justices Lamar, Starnes, and Montgomery never imagined that there would be a woman, much less a Chinese American woman from Augusta, who would one day serve on the Supreme Court. Next slide, please. But I believe that they would have been familiar with the Chinese community in Augusta. The Chinese first came to Augusta to help build an extension of the Augusta Canal in the 1870s. And so the justices would overlap with some of the time that they spent in Augusta. And my understanding is that some of these Chinese laborers stayed on and told their families and friends in China about Augusta. And that's how I understand that my grandfather first came to Augusta, through a cousin who we know operated a grocery store there in 1900. Now, I don't know when my grandfather first came to the United States. My dad told me that he was in San Francisco during the 1906 earthquake, but I have no proof of that. I do know, however, that he was in Augusta by 1914, and in the next year he went back to China to marry my grandmother, who was from a neighboring village. Upon returning to the United States in December of 1915 with my grandmother on a ship called the USS Christmas, which I think we find interesting because it was December when they came into the United States. There are records from Angel Island, which is the equivalent of Ellis Island on the San Francisco side. Those records show that my grandfather was detained for 3 days and my grandmother was detained for 12 days there. And this was very common back then because there was a federal law called the Chinese Exclusion Act of 1882, and the Chinese immigrants were barred, except there were certain exceptions made for merchants. And recall that my grandfather operated a grocery store, so the immigration officials conducted detailed examinations of my grandmother and grandfather and made sure that they fit into one of the exceptions under the Chinese Exclusion Act. They did. They were released. They stayed in San Francisco for a few months and then went on to Augusta in 1916 and started a family. And here's a picture of the Wongs. My father was the youngest of 6 children. He's the baby in my grandfather's lap. My grandparents operated a grocery store, as did many of the other Chinese in Augusta at the time. The first Chinese operated grocery store was founded in 1876, and by 1915 there were 30 such stores. And you might wonder, why were there so many Chinese stores in Augusta? Well, they didn't sell Chinese goods. Instead, these grocery stores were primarily established in the African American community, and they filled a need in that community because white grocers at the time were pressured not to serve African American customers. Justices Starnes, Montgomery, and Lamar would have been all too familiar with that dynamic. They lived during a time that was marked by conflict and civil war. And in particular, Justices Starnes and Montgomery held very abhorrent views about race and slavery. In my research, I found that Justice Starnes actually authored a novel called Billy Buck, or the Slaveholder Abroad. And the purpose of the novel apparently was to talk about the benefits of slavery as an institution. That was Justice Starnes. Justice Montgomery served as the Attorney General during the Civil War, and he resigned because when they lost, he was asked to take the ironclad oath, which was required at the time for to affirm that he never supported the Confederacy. Of course, he did support the Confederacy, so he refused to sign the oath and resigned as Attorney General. And then finally, Justice Lamar, he was from a very prominent Southern family. He was born right before the Civil War, but he was born on his grandfather's plantation. So he was part of that community, and as a child, his family was displaced by the Civil War. Next slide, please. So let's fast forward 115 years between Justice Lamar and my serving on the Georgia Supreme Court. Since that time, Georgia has grown to be a diverse, vibrant state, and I'm proud to serve the state as an Augusta Justice. My family came to this country not knowing anything about the language or the culture. My grandparents were shopkeepers. I don't have much in common with the other Augusta Justices, but I do know that I would not be in this position today without the support of my family. And my family would not be here today without the support of many, many people in the Augusta community who reached out to them. So that ends my presentation. And I thank you so much for having me here, and I'm happy to take a few questions.
Just a moment while I'm getting my mic and camera back on. And I believe we have a couple of questions. Can you hear me, Justice McMillan?
I can.
We have a couple of questions. Penny, if you could go ahead.
Justice McMillan, how common was it for justices not to win re-election?
You know, I think it was more common back then than it is now. In modern years, say in the last 100 years or so, I am not aware of any justice on the Georgia Supreme Court who has lost an election, being opposed, who has lost an election. In the last 100 years, the Georgia Court of Appeals, where I previously served, they've only had one judge lose one sitting judge lose an election. So it's not very common in modern times. I think back then there was more turbulent. You'll see, like, if you look at lists of the Georgia Supreme Court justices, and I should have pointed out to you, the Georgia Supreme Court website has a lot of information about the history of the court, including the names of the justices and the terms. And you'll see a lot of their terms were short, but some of them, they left the court for their own reasons, for health reasons or whatnot. But then, you know, I would think several of them lost the election.
Thank you. Okay, we have a question from Andrew. He said, it is my understanding that early in the history of the U.S. Supreme Court, it was not taken seriously, i.e. justice not showing up for court. Did the state Supreme Court experience similar trials and tribulations early in its history?
You know, I've not heard that the Supreme Court justices didn't take the job seriously. I mean, our court, one reason for that may be our court was such a long time in the making that the justices who served on the court, I mean, they worked really, what I've heard is that they worked really hard, and then it was a really tough life because they had to, at the beginning, ride circuit. And so they were gone a lot from their families. And, you know, of course, in those days, there's no word processing. I mean, everything was done by, research was done by the books. And so, you know, it was a very difficult life for them. And everything I've heard is that they were very diligent in their jobs as justices.
You have a comment from Lauren who says, you're an inspiration. And along that line, question is becoming a justice of the Georgia Supreme Court a career dream of yours?
You know, I actually never wanted to be a judge at all. When I mentioned that I originally was very interested in history, I was thinking about becoming a history teacher or, you know, professor. But what changed was I had a speech or debate coach from high school. I ran into him when I was in college. I went to college at Duke University. I'll give a shout out to the Duke Blue Devils because they're playing tonight in Final Four. But he encouraged me, that teacher encouraged me to look at law school. And so I didn't have any lawyers in my family. I really didn't know much about it. But I ended up going to University of Georgia School of Law. And I practiced at a law firm for many years in Atlanta. And I live in Fayette County now. In 2010, we had a couple of judges resign there due to some scandals. There were some problems with the trial court judges. And that was really the first time I thought about becoming a judge because I was worried about my community. And that's when I put in and I was appointed to the state court of Fayette County, which is a trial court position. And so I it was just an opportunity that came up as well as some of my concerns about the community that started me on my judicial career. And then a couple years after that, I was appointed to the Georgia Court of Appeals. I served on that court for 7 years, and then Georgia Supreme Court last 2 years.
Another question is, you said Justice Starnes was admitted to the bar and shortly later became Attorney General of Georgia. Could you possibly attribute that rise to maybe powerful connections?
You know, like I said, I don't have much information about Justice Starnes, but I mean, I can only imagine it's because of some sort of connection, because back in those days, there wasn't a separate office for Attorney General. It was, you were the Solicitor General for the Middle Circuit, also acted as Attorney General. And so I really don't know how he was able to ascend so quickly, but he certainly did.
Here's a question on your family history. Why did your family leave San Francisco to move to Augusta?
Well, I mean, I think what I've heard is that those laborers, Chinese laborers in Augusta in the 1870s who helped build an Augusta Canal, the history of Chinese immigration is that a lot of those laborers came from the southern part of China in the Guangzhou region, which is where my family came from. And the story is that they liked Augusta, they liked the climate. It was kind of similar to what was like in southern China. They started telling their friends and family about Augusta. And I can only imagine that's how my grandfather found out about Augusta. I don't know how else they would have discovered Augusta, Georgia as a good place to live, except it just word just kind of got back from some of the Chinese community here.
Thank you, Justice McMillan.
Thank you very much. And I just wanted to give a shout out to a couple of resources that Justice McMillan mentioned. Yes, the Justice Starnes appointment is on our virtual vault, so you can search Ebenezer Starnes on the Georgia Virtual Vault and pull that up. And we also have a published work, if you're more interested about Chinese immigration to the South. There's a book in our collection called The Formation and Development of Chinese Communities in Atlanta, Augusta, and Savannah by Daniel Bronstein, and that's available at the Georgia Archives and other libraries. So I just wanted to throw that out there.
I want to give a shout out to Professor Bronstein, Dr. Bronstein, because my family's in his book. So that it was a PhD dissertation. Okay. So that's how I found out a lot. He actually did a lot of the research and went to found the immigration records.
Great. As we've got another comment coming in, it's sort of the last slide in Justice McMillan's presentation sort of brings our symposium full circle, because Andrew Bramlett, our first presenter, mentioned Benjamin Fortson hiding the state seal during the Three Governors controversy. The room that I'm presenting from is the Benjamin Fortson boardroom. Behind me is some illustrations of the former archives building, the Benjamin Fortson Archives building, which was demolished a few years ago, and now sitting at 330 Capitol Avenue Southeast is the Nathan Deal Justice Center. So it's all sort of full circle. If we've got the pegboard chart with the strings, I think we could make a lot of connections here. I would like to thank Justice McMillan, and I'd like to thank all of our other presenters. If the presenters are still on, if they want to turn their microphones back, or excuse me, their cameras back on, so that everybody can give them a virtual round of applause. And I want to share one last slide just to wrap some things up. Let's see if I can get this figured out. I would like to, I know this sounds kind of hokey, but I would like to thank Microsoft Teams, because going into this presentation, I've had a little bit of concerns about my ability of wrangling technology, but it seems like everybody was able to present, and so I'm just thankful that the technology managed to hold up. In wrapping up, I want to send a thanks to all of our presenters, a very interesting and diverse group of presentations from excellent presenters representing law, academia, and genealogy research. A lot of the different types of researchers that we see at the Georgia Archives, and this symposium was great because it brought a lot of those threads together again. I would like to thank our attendees, and if anyone had trouble getting through into the teams, I do apologize about that, but we do make these available on our Georgia Archives YouTube channel, so you can track that down and see any parts that you may have missed. I would like to thank my colleagues on the symposium committee, Amanda Morose and John Whitehurst. They were extremely helpful these last few months getting everything put together. I would like to thank our building manager and tech guru, Alec Hawthorne, for giving us a lot of advice on how to set this up. And of course, Penny Cliff, our education director, who graciously came in and read the questions this morning, and also gave a lot of advice on how to set up the Teams meeting and how to run the Teams meeting. And this symposium would have not been near as great without all of those folks that I'm very happy to thank here. And like I said, some announcements. This and our other programs, our Lunch and Learns and our Fourth Fridays from the Archives, are available on our YouTube channel. You can get there by going to our main website, georgiaarchives.org, and then there's a little button on the main page that gets you to our YouTube channel. And then we're trying to get a little bit of a head start on our next symposium. The 2023 topic for the symposium will be Georgia, Nature, and the Environment. And so please be on the lookout for announcement about the call for papers and suggested resources for that. Once again, I'd just like to thank everybody for presenting and attending. And if there are any other questions or any other comments, we can take those real quick, and if not, thank you all and have a great Saturday.